Should be ready to go. All right, yeah, it looks like all systems are up and running, so it's not always the case. Let's get started. Get on the record here. We're in docket 5780 TE 111, the application of the city of Sturgeon Bay for approval of revisions to its parallel generation tariff. This is Michael Newmark, Administrative Law Judge for the PSC. We're connected through Zoom with the utility intervener and commission staff in attendance. We are connected through Zoom. I think I said that already. And we're here for the motion hearing for the motion of renew to compel discovery. Let's just start off with appearances on the record. So we'll just start in alpha order according to our service list with the commission staff.
Sophia Rogers here for commission staff.
Okay, and renew.
Hi, Your Honor. Ori Walswick here for Renew.
Okay, and Sturgeon Bay.
Jim Stawicki, General Manager at Sturgeon Bay Utilities.
And Kira Lair and Jacob Neely of Perkins Coie on behalf of SBU.
I don't know why. There's my screen. Okay, it's got everything a little smaller here. Since we do have a chance to do this, let's just go off the record for a sec. I just want to make sure we have the service list correctly identifying all the parties with the, has everyone been getting those emails okay? So yeah, everything should be good to go. This one is not too complicated, so hopefully I did it right this time. Okay, so let's we can clear that out. And let me just adjust one more thing and we'll get started. So, oops. Okay, there's our topic of the day. Okay, let's get back on the record. So we're here for to discuss the motion to compel from Renew, and I've displayed the filings on the screen share. So that's just what we have on IRF so far related to the motion. So I've reviewed these filings, and we, at this point, I have Renew made the last statement. For the record, I did have some sort of, I guess I wasn't quite clear as to what was going on in some of the filings, just wanted a little more clarity. I think generally speaking, I feel inclined to grant the motion, but I think there may be some stumbling blocks here, and I wanted to address that and get a better understanding what was going on. So I did want to give Sturgeon Bay an opportunity to respond to the latest reply of Renew. If you have anything else you'd like to add to what's been filed in writing.
Thank you, Your Honor. We do appreciate that because there was a fair amount of new information and new arguments in the reply, really some complete shifts. The word control appears nowhere in Renew's motion to compel. They raised for the first time that SBU has control over these documents in their reply, and included a fair amount of case law that, from our perspective, simply does not support their position in any way, shape, or form. Renew did correctly point out that the Seventh Circuit uses the legal right test, whether a party has a legal right to control the requests at issue, and that is distinct from the practical ability test, which the Seventh Circuit has also explicitly rejected. And that under the legal right test, if a contract grants a right of access to documents, or a party has some other legal right to obtain the information by virtue of a particular type of relationship, which is defined in case law, then that's what exhibits control, not the existence of any relationship at all whatsoever. That's just not the test. And so to have this come up on reply was frankly extraordinarily frustrating. In addition, the ICE Corp case that Renew cites 4 times in its motion for the practical ability test as I already noted, the Seventh Circuit has flatly rejected that test as even an option with respect to possession, custody, or control. And even the District Court of Kansas, which is the district court that issued the ICE Corp decision, has called that test, or has called the standard in ICE Corporation explicitly flawed, not persuasive, not based on any reason, and it's simply not a generally accepted test. So now we're having to face here at oral argument in front of you this afternoon all of these cases and issues that were brought up, frankly, out of nowhere, in addition to Renew saying for the first time that the reason it needs this information is because of the commission's order to the 5 investor-owned utilities to, and pardon me for 1 minute here, because I would actually like to quote this directly, for a total system economic and engineering model of the incremental and decremental costs for either SBU or WPPI's resource mix and load shape. WPPI and SBU were parties to the 5 EI 157 proceeding. They were part of that generic proceeding by virtue of the notice of investigation that the commission issued, where it deemed all electric utilities in the state parties. The order at the end of the day required that specific modeling for exactly and only the 5 IOUs. And there is no indication in this record from commission staff that that information is required to be put in on behalf of SBU in this proceeding. And there is even less indication that the specific requests that Renew has made would even fit that definition. As Renew noted, WPPI has generation, PPAs, a variety of ways that it obtains power. Renew is seeking extraordinarily specific and frankly bizarre and hard to tell what it's going to do information from PPAs. SBU has informed Renew that SBU has asked WPPI for at least one of the requested PPAs and been told that the PPA prices have the potential to cover all sorts of things: energy, capacity, ancillary services, RECs, some subset of those, all of those, any amount of this. So a price and kilowatt hours and a start and end date for PPIs bear no relationship to a total system economic and engineering model of the incremental and decremental costs for SBU or WPPI's resource mix and load shape, which is not even required to be produced in this proceeding.
Okay. All right. And that's all you have in it for initial comments?
Just frankly, Your Honor, we're just going to continue to note our frustration. SBU cannot understand what this information is going to do, how it is going to help the commission in any way, shape, or form in this proceeding. And it's our understanding that commission staff doesn't need it and doesn't want it. If you imagine that chart that they have filled out with, pick any imaginary numbers you want to insert in it, it doesn't explain how that is going to impact the proposed changes that SBU has to its parallel generation tariffs.
Okay, so just for the chart, maybe I can show that on the screen. There's the motion. That's the motion. It might not be in there actually.
Yeah, I can't remember exactly where it is. It might be in the motion, actually, page 6.
Okay. Okay, so this is in reference to the disputed interrogatory. So filling out, so So your argument, Attorney Lair, is filling out these numbers produces nothing that's what exactly? Fill in the blank.
That has any bearing on anything in this proceeding?
So it's a relevance.
Yes.
Okay.
And as we've already mentioned in our response, there is the difficulty. SBU, of course, is not WPPI. I just talked about control.
Mhm.
It is our understanding that some amount of these PPAs have confidentiality provisions restricting their provision to SBU and to any third party without consent of the counterparty to the PPA.
Mhm. Okay. So I just wanted to give you get it a little more clarity with, because it's primarily the comments in the affidavits regarding the discussions between the parties. I just wanted to make sure, in terms of our process, that's been directed to parties through the facilitating matters order, where there's a initial response, and if that response is not complete, if it's indicates that there's going to be objections to the discovery, then it sets up a process where the parties will confer, and then potentially a motion to compel is submitted. In terms of that discussion, the affidavit seemed like maybe there was a claim that process wasn't triggered properly. Just wanted to get from SBU's perspective if that's still is that a claim that SBU is making at this point?
I don't know. I mean, SBU submits that it completely responded to the requests and that there was an effort at meeting and conferring regarding that. Renew rejected the last offer to compromise. So there is SBU does not have an allegation that this motion to compel is not timely.
Okay, all right, just wasn't sure when I was reading those. Okay, and then see if there's anything else I wanted to ask you before we switched gears here, but the okay. Yeah, I guess let's hear if Renew has any response to the last comments from SBU.
Sure, Your Honor. So first, I just want to hit the control discussion. I think Attorney Lair has hit it fairly close to the mark. That's why I included the Seventh Circuit. This isn't some widely accepted method that to obtain discovery, but we're also not in federal court, right? We're sitting here in an administrative hearing process where we have an expanded world of admissible evidence, which naturally means we have an expanded world of relevant evidence for that world. And I've heard some arguments about the application. I think that's right, but what's relevant there is unfortunately, we don't have some command from the commission. This is the scope of the case, but we do have this agreed upon scoping statement, where we ask, should we grant what the utility has asked for, and is it reasonable? And I think that on the relevance issue, that's the realm of discovery here. So understand that we don't have a perfect relationship here. I think that's the point, is that the relationship is the problem. When we're looking at the IOUs, Renew, just give me 1 second here. We looked at the 6 solar facilities for WPPL. We looked at Western Mustang, which I don't believe is actually going forward for NSPW. We looked at Badger Hollow for WEC and MG&E. We can't do that here, right? Because that's just not how we're set up. So I understand and I agree that I don't think that SBU is making anything up when they say that they've asked. I think that's a very accurate statement. I understand that it's hard, but the standard is proportionality. And proportionality doesn't say that if it's hard, we can't get it. it says proportional to the needs of the case. So, if I'm looking at the comments on Federal Rule 26, I have one picked out here, but there's others. It's circumstances often dictate that the burden of responding to discovery lies heavier on the party who has more information, and properly so. I mean, maybe it's true for this case that SBU doesn't have the information. We've certainly discovered they don't have assessments of avoided transmission. We're also not exactly sure that we agree that WPPI's avoided costs are SBU's avoided costs, but that's the claim, right? That's the claim that we're assessing here. So when I'm looking at that claim and I'm trying to think, okay, how can I support that claim? This is information that I would look for. And then the other thing I would just point to is, what is Renew going to do with this information? Renew witness Kell has pointed out fairly expansively in his testimony SBU's base cost of power, and arguments that may be a better method for assessing avoided cost. So when you're looking at something like that, you can look at a range, you can take a min, a max, an average, you can compare how does the solar PPA compare to what you would expect. So I think they're important because they show what the price is that WPPI pays to lock in, so they can inform us on this base cost of our power argument. They can also help us inform Renew's position on whether, for example, the PRA is acceptable for capacity. And I just want to, step back, Your Honor, and think where are we in this process? We're at discovery. We're not at a motion to strike testimony. We're not at a motion to exclude evidence. We're not in briefing. We're at discovery, and we've got to have some ability to assess the claims in this case to even form a position. I mean, we certainly have suspicions or thoughts, but unless we can back those up, it's hard for us to even see where we can land. And just one other thing is I've heard this argument, that MG&E and Alliant, they got the PRA for capacity. But other utilities didn't get that. And certainly none of the utilities got any rate that wasn't backed up by analysis and record evidence by the commission here. I mean, we're just kind of devoid here. So that, we'd ask to compel, but those are my brief responses there. Thank you.
Sure. And just in terms,
I don't know if they were brief, but thank you.
Oh, it goes without saying. Lawyers aren't brief, but that's okay. That's why we call it briefs, right? They fool ourselves. So just concerned about this page 6 that Attorney Lair had pointed us to, the chart or the table with looks like what the information that Renew is requesting would be to fill in those numbers. So and her question, I think, was essentially, what could possibly be done with those numbers in the context of this case? Do you have a direct answer for that?
Yeah. So my direct answer is I think Mr. Kell would take a range of the prices, take the minimum, the maximum, the average, and then directly compare for solar, and that's on the base cost of power argument. I think on the avoided capacity argument, I recognize that we understand that the costs aren't broken out. We're not, it's not necessarily going to be an apples to apples comparison here, but right now it's like monkeys to bananas because we don't have any information. So is Mr. Kell going to come in and say, oh, well, the Point Beach PPA, I've got in column A that the cost for the year and the power purchased in this average price, that should be our avoided capacity cost. No, but he's going to use that as a reference to inform our position on what those actual costs are. I understand that there's this argument that, there's this PRA argument out there But we're just trying to get to the bottom of that, I guess, not to the PRA argument, but to the actual avoided cost. And, for us, WPPI does this with PPAs. They don't do it with own generation mostly. So this is kind of like our base point. We certainly would love to break it down. If we want to break it down by cost, that's completely acceptable. The goal of this table is to try and keep it as simple as possible, right? And so if there's concerns that way, we remain open to breaking things down, but I can understand why that wouldn't be wanted. And so the thought was to make it as simple as possible.
So I guess what I was curious about is Renew is not requesting copies of the PPAs. It simply wants, or I won't say simply, but what it's requesting is that SBU find the figures to put in this table.
Yeah.
Okay.
And
So,
we did.
know, I'm sorry, do you know if so you haven't seen the PPAs? Is that correct?
Yes, that's correct. And I do want to
You don't know
clarify.
if it does have a breakdown of costs.
No, I've been told that Attorney Larry's told me that the costs aren't broken down necessarily, although I'm not sure how that. I'm assuming it's going to be different. We did ask to see the Point Beach PPA, so I do just want to clarify that. That's because that one's the solar PPA. So,
and what would the value of seeing that one be over the other ones?
I think just to the extent that there's any, that's for behind the meter, you're mostly looking at solar. That could provide us with some reference to any sort of ancillary things that would be considered for solar, to that extent. So, just looking at a similarly situated asset there.
Okay. So I just wanted to ask SBU then, given the answer that Renew has just given us, that how they would use the numbers in that would be submitted for this to complete this table. It's just that's not relevant still. Is that SBU's position?
Not only is it not relevant, it's going to be extraordinarily confusing. It's meaningless information. What it sounds to me is that Renew kind of wants to do an embedded system cost analysis, sort of, but not with own generation and only with total costs in weird ways that are not going to make any sense. And that somehow that is going to translate to the marginal cost that this proceeding is actually all about. And it just simply doesn't make any sense. And it is more understandable to me why an entity made up of solar developers would want to see PPA prices and would want to see a solar PPA, but how that is actually going to relate to the avoided costs for energy and capacity and transmission that are at issue in this proceeding, especially when we are not plowing new ground here, Your Honor. In fact, the commission has had extensive discussion about this in its 5 EI 157 investigation and in the 5 individual IOU parallel generation tariff modification proceedings. And the end result is the same marginal costs that SBU is putting in here. LMP is the marginal energy cost. The planning resource auction is one type of the marginal capacity cost. A version of cone is another type of the marginal capacity cost. These are the exact costs that the commission has already found to be the parallel generation rates appropriate for the 5 IOUs and appropriate out of 5 EI 157. I don't know what Renew is trying to do here, to start over somehow, even though SBU has had this application to modify its parallel generation rates. It has had an application in front of the commission since 2019, and it just desperately wants to modify its rates the same way the IOUs have been allowed to modify their rates. And somehow that involves, we've got to go, as we mentioned in the response, Your Honor, it is SBU's understanding that the contents of the PPAs that are subject to confidentiality provisions got to get the counterparty consent for every single one of those. This is not something that is just like grab, plop, and that's it.
Mhm.
And we have to go through all of this, and I still don't understand what this is going to turn into at the end of the day.
So I am sensitive to the substantial evidence argument that Renew made. That, I mean, I don't know if we can simply by route cut and paste the determination that the commission made in the generic docket or the IOU dockets and say it's reasonable and for these utilities, and therefore we can accept the same methodology, the same cost determination for SBU. How would you argue against that perspective, Ms. Lair?
May I ask for just a bit more clarification, Your Honor? Could you, I'm sorry.
Well, I think what I heard Renew saying is that we need the backup information in order to come to the same conclusion that we did in the IOU dockets. Rather, that we simply can't accept that the decision in the analysis the commission made in the IOU dockets would apply to SBU without seeing background costs.
I think cherry-picked, confusing, bizarre amalgamation of costs is not going to be helpful to this proceeding.
Okay, but on top of that, where is the substantial evidence that's being presented? So what I so far understand is that SBU is linking the determinations made in the IOU cases as the basis for its presentation here. I'm sorry, in the basis for its application and how it wants to set those costs. But what substantial background information does it have to support that conclusion?
Thank you, Your Honor. I'm sorry, I just wasn't processing that correctly. So the information is that, so SBU is an all requirements customer of WPPI. SBU has put testimony and information in the application that WPPI buys all of its energy from the MISO market, sells all energy that it produces, and it does have generating units, into the MISO market, sells all of its capacity, PPA, owned generation or otherwise, into the planning resource auction, buys any capacity it needs to meet the remainder from the planning resource auction. This is how it functions, and this is how it functions like the investor-owned utilities. Its marginal costs are the same types of marginal costs because it's functioning in the same markets.
Then I did have a question for SBU with respect to the PPAs. So I know there's been you've made the statement that third-party consent would be required to release the information. Now, none of us have seen the PPAs, so is there a provision that the information can be released under order of law?
I don't know, Your Honor. I haven't seen the PPAs either.
So I know that was also stated that commission staff, it was stated by SBU that commission staff apparently doesn't want or need this information. I just want to know if staff had any opinion to give with regard to the motion.
Thank you, Your Honor. I appreciate the opportunity to clarify that point for the record. I've informed both parties that staff isn't taking a position on this motion to compel. That doesn't mean that we're siding with one or the other. We generally favor completeness in records prepared for the commission. It generally leads to better outcomes to have more information in the record. We all know how to handle complicated and confusing information and distill it down to important points through the process. We're all very savvy, technically fluent adults here. And so, regardless of the merits of any motion to compel, I think staff, it's fair to say that we do favor completeness on this particular issue. We're not taking a position. We can proceed with our work without this information. Renew is the only intervener in this case. And despite some discussion today, this is a new issue before the commission that hasn't been decided, and it certainly hasn't been decided in any other case. This is the first municipal utility update of its kind, and so frankly, if Renew has explained why it needs the information, staff isn't opining as to relevance. The relevance standard is pretty low. Under Chapter 804, if Renew is saying it needs this information to make its case, I'm not so interested in, I think Renew has gone through motions here to get this information, and at this point, it's not appropriate in my mind to push Renew to demonstrate exactly what they're going to get out of this. The standard is that the request might lead to some information that's relevant to not necessarily the commission's decision, but actually to Renew's arguments. And I do think that's easily met here. We're not weighing in besides, those comments, which are mine. But I think it's important for the commission to have a complete record. I am unfamiliar with the privilege concerns, and it sounds like maybe Attorney Lair is unfamiliar with the PPAs. We can certainly work out, attorney size only, or, some kind of confidential handling standard. We've done that lately in some other cases with much more sensitive information even than this.
Mm-hmm. Okay, thanks. And I did want to just come back to a point that I think Attorney Lair, you did indicate, sort of ask the question why Renew would need this information, and I just wanted to be sure that whether SBU has any credible evidence that releasing this information to Renew under some sort of confidential agreement or order would risk the unauthorized release of that information.
Well, Your Honor, this gets a little bit to something that I think we're kind of glossing over. SBU is not WPPI. SBU has a confidentiality agreement with Renew in this proceeding. SBU is not a party to any of these PPAs. It would certainly, from SBU's perspective, be extraordinarily inappropriate for these PPAs or this information to be used for anything other than this proceeding. And the party to this proceeding is not a party to those PPAs.
Right. But my question is, do you have any credible evidence that the information would be used by Renew for an unauthorized purpose?
I have no information that it would be used for an unauthorized purpose, and SBU obviously would request that anything be confidentially protected in ways that it doesn't know how to do.
I see. Okay. So this does raise a number of complications, and I think Attorney Rogers is correct that it is a fairly unique situation here. But I think in terms of relevance and in terms of creating a record with substantial evidence, and also in terms of Renew's rights as a party, I believe that we do have the request should be granted, the motion should be granted, that the information should be provided. I think that the point of having interveners is to allow for a perspective that may not be presented by commission staff or the applicant. And I think in this case, more than any other, I think Renew has a substantial interest in the outcome of the case. Although, it's been intervener in many cases before the commission and provided valuable information to the commission for making its decision in many proceedings. This one in particular, it has a substantial interest because of its membership related to renewable energy. However, that right shouldn't be also the barrier it faces to getting information in order for it to meaningfully participate. Like I said, although commission staff didn't intend to use it to request this information or present it in that analysis and its presentation of the case, that's certainly no bar for an intervener to do so. Interveners are encouraged, actually, that's part of the standard, to provide information that would be useful for the commission. So although its request and use of information in order to create its analysis might not be something that the utility anticipated or staff was considering on its own, I think it's valid and would promote the record. And like it was mentioned, we are in this discovery phase. I think the relevance issue, I think I still need to use the statutory standard of relevance, which I don't think it really does. I don't think it is much lower than the regular relevance standard, although maybe in practice it's treated that way. But I think it does. I think in this case it does lead to relevant evidence. I think that when we look at the claims that SBU makes in terms of what it's claiming is avoided costs and how its rates should be set in order to be reasonable, Renew's perspective is different, and there may be a different analysis, and I think it's valid for Renew to test the conclusions of SBU and present an alternative. Whether that alternative becomes something that is credible or is something valid in terms of expert analysis, or whether it can be criticized and countered is an issue that we'll save for the evidence and the witnesses to debate. But in order just to get that information, I think it's valid and relevant. So that leads us to a few issues with trying to comply with that order. First of all, just getting access to the documents, and of course we'll have I believe I don't doubt that parties could enter into a confidentiality agreement to protect that information. I could also order that it not be used in any other context, and we'll simply do so now by this order, that any information released in relevant to this dispute shall remain confidential. We'll file it confidentially with the commission, and commission will treat it confidentially, but also parties as well will need to do so. In terms of the details of sharing the information, that might require some more discussion, and it also may require the involvement of WPPI. Now, WPPI is heavily involved in this case in terms of its witnesses. It is presenting witnesses on behalf or on behalf of SBU. I believe the application and much of the analysis is done by WPPI. So I think there's many avenues by which we can engage and obtain this information, and I'm willing to entertain ones that can be amicably reached, but there are other ways to get the information. So I'm not sure. I think first of all, what this whole process may require is a delay in the schedule, unless something can be quickly turned around. And we do have, so direct from all sides is already filed, and I was hoping, that's why I held this hearing as quick as I could after filings were completed on the motion. But we have a rebuttal deadline coming up on the 19th. Now there could be an extra round of testimony, but I don't before the hearing, but I'm not sure if there's a way to get this information and have a reasonable amount of time for Renew to conduct its analysis, and then the rebuttal to that, I'm sure, will be intensive as well. So my inclination is to suspend the schedule in order to get an agreement on how we obtain the information and how much time Renew might need to process it. Although I can withhold that and see what parties can come up with quickly. So any thoughts about how we go about pursuing this?
Your Honor, I would appreciate not suspending the schedule
I
and
understand.
seeing what we can do there. As I mentioned, we're coming on 5 years already with this.
Well, let's make sure we understand that. I think the commission put this, I mean, I'm just guessing, but my assumption is that the commission put this on hold in order to conduct the generic. So I don't know how much of this has been, quote unquote, delayed by anyone here present, but let's work on the situation as we find it now. But I understand SBU has been looking forward to a new rate for quite a long time.
Thank you. What I would appreciate is the opportunity to take this back and talk about it. And I frankly am not prepared to present anything today.
Okay. And I understand this is unorthodox given the parties, although I can facilitate some of this, and I believe, if necessary, I'll do that, and it may be to SBU's benefit to get things done quicker that way. So if you need an order from me, if you need, and let me just lay out some of my ideas, and I'm not going to order this, but I think these are options. So one option is that I think, and this may take a lot longer than we want, but to subpoena WPPI and have them produce the evidence. So it's more of a direct subpoena to them rather than through SBU. Another option is to make WPPI a party in this case, and I'm not adverse to doing that on my own if necessary, and I've done that in the past, where I've seen a related party whose interest will benefit the commissions and whose participation directly in a case will benefit the record, and have made them a party sua sponte. In this case, I think that the connections are so close that it really it's not too surprising to be doing that in here. But and the other idea would be to, if the PPAs require an order, I'll produce one for you. I'll make that happen so you have that. The other complexity may be SBU seeing the PPA. Again, we could do an attorney's eyes only provision. You do have, because SBU does have outside counsel, so that's helpful. And I believe because Renew is not a independent power producer, it's an umbrella group, it's a membership organization. I think they also do provide that third party protection, and we'll make whatever whatever confidentiality measures we need to impose, we'll make sure that that information remains in-house to renew. So I'm trying to think of other angles that may be roadblocks, and hopefully alleviate those before we face them. So I don't know if there's any other ideas we can put on the table in order to facilitate the process. But I guess generally speaking, I don't know if Renew can comment on this, but if witness Kell was able to obtain the information that Renew is seeking, how long do you think it would take for that analysis?
Yeah, Your Honor, we were, ideally, we were thinking at least a week before Sir rebuttal. Understand that, that's coming up fast, and probably potentially too fast for this. But a week, and depending, we could work that down as much as possible. Maybe we could even get to 3 days. If we need to. I think we'd love to see this proceeding move along as well. Not trying to delay. So to the extent that we can get there, so if there is another round of testimony, I suppose we could do something like that too, as long as we had a couple days to prepare that. By a couple, I mean at least 3. But
yeah, we need a response to it as well. I'm pretty sure SB would want to do that in writing. So yeah, we have to work that in. So yeah, doesn't give us a whole lot of lead time for that. So so I don't know if that's all we can accomplish today, but is there anything else, any other offers for streamlining this process? I mean, one option would be. Yeah, I see our issue here. Okay, yeah, I don't know if that's really an option. Okay, yeah. So I guess, and so where do parties sit at this point? Can we make a plan here, or we're not really prepared to do that?
Your Honor, what would be the best and easiest mechanism for you to get back to you?
Oh, okay. Through Attorney Rogers.
Okay.
Yeah, I think that would
So, Judge, what I would suggest is suspending the schedule that we have now until Attorney Lair is able to get us a date, an expectation for when this information will get to Renew, and we work out any privilege issues. And then I think we're looking at starting up the schedule again with potentially one extra round of testimony. Is that what I'm hearing?
Well, yeah, I guess.
Your Honor, I heard not suspending the schedule and potentially having another round of testimony when we can get more of a sense of what this looks like.
Well, let me ask, I mean, is staff considering filing rebuttal to Renew, or have we put in a response to the application?
Well, staff would certainly want
I mean just this current round. So say like none of this is happening. Say, was it preparing to respond? Because I think that's the only, so rebuttal at this point is really the applicant's rebuttal, right? Unless Renew wants to respond to staff.
We're not going to respond to staff, Your Honor.
Okay, and then was staff thinking about responding to Renew and rebuttal?
No, I'm sorry, I'm trying to still work this out, I suppose.
Yeah,
So,
I'm just thinking out loud here because I'm wondering if we push the rebuttal back or forward and then see at least giving the time for giving that space for getting the information in and then having a new rebuttal round potentially when that information for at the time when Renew can present its testimony on the new information. Or just because it's a third and a. So for example, just for kicks and giggles, like making the rebuttal on the 26th. And then with the belief or the anticipation or the hope that information would come in, Renew could get its analysis done. And then rebuttal could be presented in response to that analysis.
So just so I'm understanding, Your Honor, we kind of move the rebuttal.
Forward.
How is that going to work for SBU to be able to respond there?
Right. Well, I mean, we could push rebuttal to the 2nd if we want to keep the 3rd as a hearing date. I'm sorry, the 7th is the hearing date. Oh, I was looking at the 3rd. I don't know why. Okay. Well, we could push rebuttal later than rebuttal. There's actually a lot of room to push rebuttal forward. So I missed that. Okay, so that's maybe that's just conceptually what could happen if this works out. I don't know if we really need to change the schedule at this point, but I think we could essentially attempt to keep the hearing date May 7th with the anticipation that we could work out new deadlines for the testimony and at least have 2 rounds. But I would say, I mean, I think it might make sense to, or maybe just add another round right in the middle. So if we
Yeah.
add 26th, that might work. So the SBU can respond to what's on the record so far and then have an extra round in between. So I didn't realize there was so much time between rebuttal and the hearing. So that's actually fairly helpful. So, I mean, we can just leave it at that with that understanding, and the details we can work out, or parties hopefully can work out. But it would all be conditioned on getting the information and with enough time for Renew to meet whatever deadline we set for that interim filing of testimony. Can I clarify that anymore? I think seeing a lot of confused faces here.
Well, Judge, I'm wondering when this information will be coming.
Right.
Staff will need time, and I haven't heard.
Yeah, I mean, there is, as one hopefully can expect and appreciate in this situation, as one who has not seen the PPAs and a representative of SBU, I cannot say that right now. I can commit to trying to find out what I can find out as soon as possible and return to parties as soon as possible, including next week. But because I have no substantive information to offer at this point, it seems I appreciate the judge's flexibility as to, as soon as there is additional information, using that to make any modifications that may be necessary.
Okay. Well, yeah, I think that's probably the best we could do right now. I guess I don't know why, but I get a feeling that we may need to have those. If I need to look at the PPAs to see, under seal to see the provisions of confidentiality, how would that occur exactly. I'm not really sure exactly how that would happen. But I would say that may be necessary, so let's just be forewarned about that. And I'm not sure exactly how that would occur, but if there's some sort of dispute about whether the information can be released because of the third party agreement and how that gets overcome, I think, there may be a situation where I will need to see that PPA under seal. And again, if that requires WPPI be made a party, then that may be necessary. But if there's a different way of approaching that, I'm open for that as well. So,
I understand that, Your Honor, and that makes sense and can't offer too much more again at this moment.
yes, I understand. Just want to get out the ideas here so no one's surprised. And then, so like I said, I believe I can keep the May 7th hearing date with the understanding that the information will be provided in a timely manner for us to work out getting an analysis from Renew and the response from SBU and staff prior to the hearing. Otherwise, if that can't be done, we'll need to postpone. But at this point, I don't know what else we need to take care of at this time. Anyone else have anything? No?
Judge, scheduling is, a tricky thing for staff, juggling a lot of different balls. So if we are having trouble getting the information teed up, I will raise alarm bells and ask for a suspension of the schedule. It does affect, we have a lot of other cases going on, a lot of other work. And so it seems tight to me, but we'll see.
Okay. Well, I think I said, if it's going to be an agreement, it needs to include staff. Otherwise, parties can request can make a request to change the schedule or not change the schedule to propose the additional round of testimony. But we can I'll need to then decide what the schedule should be if there's a dispute in that. But that includes staff's acquiescence to whatever anyone else is proposing. Okay. Is that it then? All right. Well, thank you everyone for joining us on a Friday afternoon on a beautiful day. I appreciate the time and attention we're taking to this. Hopefully we'll make the best record we can. So thanks very much. We're adjourned. Take care.
Thank you.
Thank you, Your Honor.